I feel like one of those rock singers who has a microphone in the hand. Ladies and gentlemen, welcome to the 5th year of our Water Colloquium on California's water, sponsored by the Water Resources Center Archives, a very unique asset for the entire University of California system. We are fortunate to have it here in our Berkeley campus. 5 years ago, we started this colloquium series with the purpose of educating ourselves. All of us, the brilliant faculty on this campus who are experts, we are all experts in some little area. There are lots of things which we do not know about. And in this water colloquium, we have tried to arrange ourselves in such a way that we can, the students, the faculty, as well as the public, can get itself informed about water in California. And a venture like this has to have both intellectual support as well as moral support and financial support. And we are fortunate that this colloquium series is supported by several deans, the deans of engineering, letters and science, natural resources, Bolt Hall School of Law, the executive vice chancellor, Paul Gray, the director of the Earth Sciences Division of Lawrence Berkeley National Laboratory, and the Groundwater Resources Association of California, a professional society which is deeply committed to wise use of groundwater in California. And so with this support, we have been able to put this together and run it reasonably well and successfully. And from the faculty side, we have an excellent group of faculty drawn from around the campus who help identify and invite speakers. Professor Joseph Sachs, who is here from law, Professor Sedlak from civil engineering, Michael Hanneman from economics, and Matt Condal from landscape architecture, and myself. We put this technical colloquium together, and it is administered through the Water Resources Center Archives, and Linda Vida and Nancy Nowitzki, who is here, they take care of all the logistics and arrangements. So that's how we are doing it. Welcome you all. And today, for the first time, we are going to hear about a very new topic which we have never heard before, about coastal waters. And to introduce our speaker today, I invite Linda.
Thank you. It is actually a very particular pleasure for me to introduce Peter Douglas, Executive Director of the California Coastal Commission. I grew up in San Francisco, and of course, like any of you who've gone to the coast in California, you have great memories. And I have some very exceptional memories of being at the coast, spending time at the tide pools, etc. And so I very much admire the work of the California Coastal Commission. Mr. Douglas emigrated to the United States from Germany in 1950. He attended Berkeley briefly from 1960 to 61. He did receive his undergraduate degree from UCLA in 1965, and then earned a degree in law at UCLA in 1969. In '72, Mr. Douglas served as a legislative assistant to Assembly Member Alan Siroti and co-authored Proposition 20, which was the California Coastal Zone Conservation Act. From 1972 to '75, he served as chief consultant to the Assembly Select Committee on Coastal Zone Resources for the California State Legislature. He then served as senior consultant to the Assembly Committee on Natural Resources, Land Use, and Energy, and was the principal author of the California Coastal Act of 1976. the act that made California's coastal management program permanent. He was made Chief Deputy Director of the Commission in 1977, and since July 1985, he has been the Executive Director of the Coastal Commission, the third director. The list of his professional achievements, including lectures, published articles, his service on national and international committees, and awards that he has received are too extensive to go into detail here. Please join me in welcoming Peter Douglas, who will tell us in more detail about the Coastal Commission, how the Commission goes about making its decisions, and about the recent increase in requests from coastal cities to build desalination facilities. And I'm sure that he has a lot of interesting stories to tell, and I hope that he has time to tell us some of those stories. Peter Douglas.
Thank you, Linda. This works. It's a pleasure for me to be back at Berkeley, but as it was in 1960, it was just as hard to find parking here today as it was then. I don't know how many of you came in here earlier and saw what was behind this screen. It was just arrows and diagrams and like spaghetti on the wall. And it reminded me very much of the political process that led to the enactment of the Coastal Act. And I mean, literally, could have been a diagram of how California's coastal management program came into being. And by the way, you'll have to bear with me. My voice is a little difficult. I just finished a bout with cancer and throat cancer, and I'm dealing with, which I think successfully put behind me, but I'm going to have to do a lot of water intake, and you'll have to bear with me. I wanted to give you a little bit of background on the Coastal Act, what we do, what the issues are, what the major challenges are that face the Coastal Commission, and then talk a little bit about water issues relative to desalination and the push to use ocean waters for potable water to take up the loss or the lack of water generally in the face of a growing population. Those of you who live here in the Bay Area know one of our sister agencies, the San Francisco Bay Conservation and Development Commission. That was an agency created in 1965 and actually was the first coastal management program in the world. It was created to protect San Francisco Bay against extensive new filling. So filling in of the bay was the biggest issue, as well as the loss of public access around the bay. BCDC, as it's known, was created in 65. It was made permanent in 1969. And it served as the model for the California Coastal Protection Program that was enacted by a vote of the people of California. I went to work in the legislature in 1971, and my first job was to draft the Coastal Act on behalf of the environmental community for the legislator I worked for. And we tried in 1971 and 72 to get it through the legislature, and we just couldn't. There was too much opposition from the oil industry, from the ports, local governments, the real estate industry, developers. The array of opposition was enormous, but there was tremendous public support as well, especially because of stories that were coming in about loss of public access along the coast. Those of you who were around in the 60s know about the Sea Ranch on the Sonoma coast. That's 10 miles of coast that had been accessible to the public, and because of a development for a second home subdivision called the Sea Ranch, 10 miles of coastline was overnight blocked off to public access. And there were stories like that up and down the coast that led to a tremendous amount of public support to protect the coast and to enact a coastal management program similar to the San Francisco Bay program, but for the entire coast. So we took the San Francisco Bay program as a model, both in terms of what you can do and do right, and what you can do differently to do it, to not do it wrong. And one of the big differences was the breadth of jurisdiction that the Coastal Commission has compared to San Francisco Bay Commission. So we couldn't get it through the legislature, and decided the environmental coalition that supported the Coastal Act decided to turn to the initiative process. That was in 1972. And another attorney and I wrote that initiative in one morning in San Francisco, ironically just a few buildings from where I work today. And that was sent out to about 20 people to review, got about 2 comments back, and that's how it qualified for the ballot. And it was voted on in November of 1972. It was passed by about a 55% margin. I don't think that we'd be able to pass a coastal initiative today simply because of the change in the laws and the cost of elections and a variety of factors that have really kind of changed the whole way the initiative, or at least the citizen initiative process, works. We didn't pay any signature gatherers to get the signatures that were necessary to qualify for the ballot. We were outspent 20, 30 to 1 in the campaign for the proposition, but we still won. We won because the public really cares about the coast, and especially Californians who identify with the coast as kind of the geographic soul of the state. So that was 1972, and it set up the Coastal Commission as a temporary agency, and we did that for political reasons, and said that, okay, Coastal Commission, you prepare a constitution for the coast. You prepare a plan for the conservation and use of the California coast. That goes back to the legislature in 1976, and if the legislature doesn't do anything with it, this whole experiment ends. In 1972 as well, in fact, in October of 1972, a month before the initiative passed, then President Nixon signed into law the Federal Coastal Zone Management Act, which is very important to California and all coastal states, which gave us impetus for the initiative and provided a level of support that I'm going to talk about again in a little while, but it was very important and continues to be very important to coastal management, coastal protection in California and other coastal states. That was in October of 1972. The coastal plan was prepared in 1975 and submitted to the legislature in at the end of 1975. And then in 1976, we had to pass a law that either would make the Coastal Commission and the Coastal Act permanent, the act that was recommended in the coastal plan, or it would all self-destruct and go out of business. We passed that law on in the 11th hour and 59th minute, literally the day before the end of session, by 2 votes. It's a fascinating story how those 2 votes were garnered. It's a little bit sleight of hand by a politician who now continues to be a politician locally, who was in many ways as clever then as he is now. He happens to be the mayor of Oakland. And he and his chief of staff, who wasn't quite as clever because he just got recalled, Ray Davis, and we got the votes that we needed to pass the act, literally at the last minute. And that Coastal Act of 1976 made permanent California's Coastal Protection Program and the Coastal Commission. Let me go through a few fundamentals here in terms of what the law entails that's so important. I think the obvious is that the coastal zone is a special piece of geography. Like San Francisco Bay, like Lake Tahoe, the coast is a special geography deserving of special treatment, special attention. It also was clear that we needed state-level policies to protect the coast because local governments, and there were some, I think there were about 60 local governments at the time, but there were a total of over 150 special districts, state agencies, and other entities that made decisions that affected the coast. So there needed to be a central kind of integrated state-level agency and state-level policies to guide use and conservation of the coast. So state-level policies that combined planning and regulation, which was one of the lessons we learned from San Francisco Bay, that you can't just have planning in isolation. You have to marry planning with regulation, because if you just have a plan being prepared, by the time it gets done, the development that's taken place has rendered that plan moot. And so if you put the two together, you can make decisions in terms of actual use on the ground while you're shaping the plan. And that's what happened in the 5 years between 72 and 76, that the Coastal Commission, and there were 6 regional commissions, made a lot of development decisions that preserved options for the planning that was to follow. So putting those two together, that was a fundamental principle. Also, to have an independent part-time commission. We knew a lot of permanent agencies in state government, but we really felt it was important to have a part-time commission made up of a diverse representation of people and appointed separately, in part by the governor, part by the state senate, part by the assembly, and I'll get back to that in a minute. Another important part was not only to have an independent commission, but to have an independent staff. That is, a staff that works for the commission, but independent in the sense that the commission couldn't tell the staff how to write its reports. And that has been an incredibly important part of the success of the program. That is that we do our professional job best to make recommendations to the commission. The commission then makes the policy decision of whether or not they agree with our recommendation or not. The independence of the staff is really critical. Also built into that law was the precautionary principle, which I thought was pretty forward-looking in 1971 and 72 to be incorporating the precautionary principle into a law, which basically said, if in doubt, don't approve. If you don't know what the adverse impacts are going to be, don't approve the proposed development. And that was embodied in and memorialized in both the Coastal Initiative and the Coastal Act of 1976, and that put the burden of proof on the developer. Anybody who wanted to change the status quo would have to prove that their project wouldn't adversely affect the environment. It wasn't the responsibility of the agency to prove that a development that's being proposed would have an adverse effect. It was a developer's responsibility to show it wouldn't have an adverse effect. Very significant fundamental principle of that law. Also pulling together science and policy. That was a very important element. Clearly, science-based decisions are important to not only withstand attack in the courts, which we knew were going to come, but also important in terms of just public support. So science and policy together is a very important component. One of the most important elements of the Coastal Initiative was the role of the public. Since this is the people's law, it is, to me, probably the most participatory law or planning process that I've ever run across. That coastal plan I mentioned to you, that was put together by 6 regional commissions, 1 state commission, literally hundreds of public meetings, thousands of people participating in the preparation of that plan. It really was a public plan that relied on public participation, and the whole process was designed to be open, transparent, and encouraging of public involvement. And in fact, one of the most significant accomplishments that I see of the program is the empowerment by the Commission of citizen groups locally to participate in decisions that affect their community in an effective way through the Coastal Commission. So public involvement was a key fundamental component. And I mentioned the transparency and openness of the process. Local governments were clearly turned to as a partner in this process, so they have a key role, but the state, through the Coastal Commission, had the overarching responsibility to apply statewide policies, and then the concept of judicial review, so that if a decision by the Commission was opposed by either the party proposing it or a citizen group, they would have a remedy by going to court to seek to challenge the decision. Those are some of the major fundamental components. In terms of the structure and the jurisdiction of the Commission is made up of 12 members. There are, right now, this is not the original Commission, but right now, there are 6 members of the public and then 6 locally elected officials. They're equally appointed, that is 4 apiece, by the governor, the Senate Rules Committee, and the Speaker of the Assembly. We did that intentionally because we felt that it was really important, aside from the fact that Ronald Reagan was the governor at the time that we passed this, and he was vehemently opposed to this state-level intrusion on private property rights and home rule and local government. And we didn't want him to control the appointments to the Coastal Commission. We made it such that no one ideology would control the Commission. And I think that has been the primary reason why the Coastal Commission has been as successful as it has, because no one ideology dominates the Commission. Each House and the executive only appoints a third of the Commission. So that was a very important component. It was also a component that some people challenged over the years, especially the Pacific Legal Foundation, one of whose founders finally found a judge who agreed with him, and we had a decision here a couple of years ago declaring the Coastal Commission unconstitutional because of the nature of this appointing process. The Court of Appeals in Sacramento, 3rd District, upheld the trial judge's ruling, and I personally think that they did that because they knew that we could strengthen the Coastal Act. We could strengthen it in a way that I know I had tried, others had tried back in 1972 and 76, and that is to have fixed terms for commissioners. Instead of appointing commissioners at pleasure, where they could be removed anytime the appointing authority didn't like what they had just done, to give them fixed terms. We could never get that through the legislature. But because of the Court of Appeals decision, the legislature, Governor Davis called a special session, and in record time, we got a bill through that established fixed terms for the legislative appointees to the Coastal Commission. So now they serve for 4 years and aren't subject to the political pressures of being removed anytime the appointing authority didn't like their vote. So actually the guy from the Pacific Legal Foundation, I've been on panels with him, and I always thank him for bringing this lawsuit because he unwittingly strengthened the Coastal Commission in ways that the environmental community was never able to. And we're now working with commissioners who are on fixed terms, who are appointed by the legislature, not the governors. They continue to serve at the pleasure of the governor. But that structure is, and that whole decision is before the California Supreme Court on appeal, and we have no idea when they're going to decide. Every month we expect them to make a decision. It's been there for almost a year. But they obviously are in no hurry to address this issue because I think that they think that the legislative fix solved the problem. So that's our hope. They obviously don't think it's a crisis, and we'll just wait until they do decide that decision. The other question is the jurisdiction in terms of who it applies to, where it applies, and what it applies to. The Coastal Act is probably the most comprehensive reaching coastal management program in the country. The area it applies to is a coastal zone that's mapped, specifically mapped. The legislature adopted maps of the coastal zone. It's one of the biggest weaknesses in the law because the boundary of the coastal zone is a political boundary. It's not a geophysical boundary. The coastal plan in '75 recommended the watersheds be used because of the drainage into the ocean as an inland boundary. Politically, that wasn't possible because in some places it would have reached 30 plus miles inland. So the way, and it's a whole story of how the Coastal Act was enacted in '76, but I was working for the Assembly Resources Committee at the time, and the chairman came up. We took a bill that had passed the Senate that had nothing to do with the coast, had to do with Caltrans and some trees that were going to be cut on Highway 101. But it had passed the Senate. It was in the Assembly Resources Committee. And because the Maine Coastal Act had died in the Senate, the chairman of the committee decided to ask the author of that Senate bill, can we take your bill and magically transform it into the Coastal Act? And that's what we did. We ended up amending the Coastal Act into this bill that had passed the Senate so that we bypassed the roadblock in the Senate, had it over in the Assembly. And one of the key strategic decisions the chairman of that committee made, since we did this in the summer, in June, it had to be enacted by August. There wasn't much time for hearings. I and a colleague of mine rewrote the bill. We didn't use what had been on the Senate side, thinking that was way too cumbersome, and rewrote the act. So it appeared for the first time in June, and we had hearings down in LA, and the chairman said, I think the way to deal with this is I want a map of the coastal zone. So ask the Coastal Commission in 2 days, I mean, it was really short, to draw us a map of where they think the boundary ought to be based on the language in the previous bill on the Senate side. And what we'll do is we'll have the hearing and we'll put those maps around the room, which we did. We had the hearing down in Loyola, Marymount, and we had the whole hearing room, the walls plastered with these maps of the coastal zone. And it was a brilliant political move because the developers and local governments spent all their time looking at the maps and arguing where the lines should be, and they weren't paying attention to the policies in the language of the law, of the bill. And so there were a lot of adjustments made to the boundary, but none of the policies got changed. And so it really took their focus off of the policies of the act, and that's why we were successful in getting such a strong law passed. But it's also the reason that we have such a, in many ways, inadequate coastal zone boundary. But it's that boundary which is mapped, that's the inland boundary, and then it applies to everybody. Special districts, Caltrans, state agencies, school districts, individuals, everybody who proposes to develop anything in the coastal zone is subject to the Coastal Act. And it applies to everything. The only compromises that were made were relative to new power plants. There was a complicated process that was set up in the Coastal Act that divided responsibility for siting power plants, and the Forestry Act dealing with timber harvest plans. But everything else was within the jurisdiction of the Coastal Commission. So it's very broad, and it applies to everybody. So the jurisdiction is really significant. It did not include San Francisco Bay. The boundary went essentially across the Golden Gate Bridge because San Francisco Bay already had its commission, and politically it just didn't make sense to try to apply the Coastal Act in the Bay, even though the Coastal Act was much more comprehensive, much more extensive in terms of its reach. It didn't just deal with filling of coastal waters and access. It dealt with a whole variety of policies relative to conservation and use. The resource policies in the Coastal Act are significant. Those are the heart of the law. And they deal with, number one, public access, maximizing public access. That's clearly, that was the primary reason that we think the public passed Proposition 20 in 1972, because of the loss of public access, and they wanted that protected. And that was a key part of key policy in both the Coastal Plan and then in the Coastal Act. Protecting habitat, that is habitat along the coast, wetlands, riparian habitat, woodlands, all ecosystems along the coast, protecting marine systems, marine ecosystems, the biological productivity of marine waters, the quality of marine waters, dealing with issues such as hazards along the coast, industrial facilities, protection of agricultural land, commercial fisheries, recreational boating, a whole variety of policies that are set forth in Chapter 3 of the Coastal Act, including the protection of scenic resources, the scenic values of the coast, and development policies that said we should develop where existing services exist to accommodate new growth and not have leapfrog development along the coast. And if you drive the California coast, which is perhaps the most accessible coast in the country, there are a lot of people who ask me all the time from other states, other countries, how has California been able to keep the coast as open and as undeveloped as you have? And the answer is the Coastal Act. A lot of blood, sweat, and tears were shed to preserve the coast as it is today, which most people have no idea about, and they take it for granted as it is. But it's because of that development policy. In fact, after the '72 initiative passed, there was no new speculative second home subdivision approved along the California coast, and we haven't approved any since. So that whole industry came to a grinding halt on November 7th, 1972. So those are the policies that guide the development decision. And by the way, when I talk about jurisdiction and the breadth who it applies to, that includes the ports. So the ports of LA and Long Beach and San Diego are within the jurisdiction of the Coastal Commission. Relative to the management, I already mentioned the bringing together of regulation and planning that was made permanent in the Coastal Act. The role of local governments, and the idea was, okay, state policies would be applied at the local level through local coastal plans, and then those would be approved by the Coastal Commission, but then local government would have the primary responsibility for implementing them. And that's a key partnership role. That was a key compromise made in '71, '72 with the League of California Cities and Coastal Counties, so that they would have a principal role in actually implementing the coastal program. Plus, they got half of the membership of the Coastal Commission. So half of the 6 of the 12 members are locally elected officials. They're still appointed by the governor and the Senate and the Assembly, but they're locally elected officials. So that's the role of local government. And public participation continued to be an important part. Another element of the Coastal Act that's so important is, I mentioned the Coastal Act of 1972, the Federal Coastal Zone Management Act. Well, a lot of coastal states thought the reason that's so important is because we're going to get grants from the federal government so that we can pay for our coastal program. I always felt that the most important element in that federal law was something that was really unique. And this was one of many strong environmental laws signed into law by then President Nixon. And that is that it's called the Federal Consistency Provision of the Federal Coastal Zone Management Act, which says that any federal activity that could affect coastal resources has to be reviewed and determined to be consistent with the California Coastal Management Program by the Coastal Commission. That gave the state, through the Coastal Commission, incredible power and jurisdiction, because not only we couldn't just have jurisdiction over federal projects without that federal law. And that has been incredibly important over the years, so that federal consistency has enabled the Commission to deal with projects like when Vandenberg Air Force Base was going to go from military launches to space shuttle launches and then commercial launches. But when they went to shift over to the space shuttle launch, since it's the only place on the continental United States where you can launch into polar orbit without crossing a heavily populated area, they had to get approval from us. And the Coastal Commission did a number of things. We said, we're not going to approve it unless you provide access to miles of beaches that had been off limits for security reasons, open that up to the public. And also, they were going to bring in water to meet this new expanded development by tapping into the California Water Project, which the county, the surrounding county, Santa Barbara County, vigorously opposed because it would have tremendous growth-inducing impacts. And so here was the Air Force going to pay for this importation of water, which then could be tapped into by communities that didn't have any water right at that point. They still don't. So it's a constraint on development. And the Coastal Commission said, no, you can't have that project. You've got to first have a vigorous water conservation program, fix your leaky pipes, institute water conservation measures, and then we'll see whether or not you still need the water. They agreed to it at the 11th hour, and they found, lo and behold, just by fixing their leaky pipes, they didn't have to spend all this money for water importation. and they never built that component. So that was very significant use of the federal consistency. Just about everybody here has probably walked the multimodal path along Cannery Row in Monterey. Well, that used to be a railroad that went out to Pebble Beach, to the mining area there, hauled out sand. That was, I believe it was Southern Pacific. In any event, they wanted to abandon that in the late 70s, and they went to the Interstate Commerce Commission and were going to abandon it and sell it to private developers to develop. The Coastal Commission said, no, you need approval from us before you sell that, abandon that right away. And they said, no, we're not subject to your jurisdiction, took us to federal court. We won in federal court. In the meanwhile, the local governments around the Monterey Peninsula formed a joint powers agency. They bought the right-of-way after that decision for a nominal amount. And now, rather than having stripped private development along that, it's the most heavily used public access corridor around Monterey Bay. But that's how it came about. It wouldn't have happened otherwise without that federal consistency provision. Also, we had the Navy proposing to scuttle nuclear submarines about 300 miles off the Northern California coast. This was back in the late 70s. And we wrote them a letter saying, you have to have approval from the Coastal Commission before you dump these submarines off the coast there. And we think that if you do that, it's going to really adversely affect commercial fisheries because people aren't going to buy fish that they know might have been radiated by these old nuclear subs sunk off our coast. And so we see that it's going to have tremendous impacts, and we wrote them a long letter. They scuttled the project, not the submarines, and then moved it off of the southeast coast. And I don't know exactly where they ended up dumping the submarines, but it wasn't off of Northern California. And another one like that was EPA's brilliant proposal to deal with toxic waste by putting them onto a ship and going about 250 miles off the Golden Gate and burning it. And there too, we wrote them a letter saying, gee, the winds happen to blow this way. You will need approval from the Coastal Commission, explaining to them all of the issues that we saw with their proposal, and that too went away. It also had a lot of public opposition, so it wasn't just the Coastal Commission. But in any event, that federal consistency authority was extremely important. Let me rush through some of the other issues here because I think it's really important that we have some time for questions. In terms of, and we also have, the Commission doesn't just regulate and deal with planning and federal agencies. We also have a public education program. We have the beach cleanup program, which hopefully this Saturday a lot of you will join. It's now a statewide program. We get 55,000 people out every year on this day to clean up trash and debris along the coast and rivers and lakes. That's our program. We have an Adopt a Beach program. We've got a Plastics in the Ocean program. We have a school curriculum program. So we do something other than just regulate. In terms of major issues that are facing us today, one of the weaknesses in the Coastal Act was that these local coastal plans that were to be adopted, we can't update them. We can't force them to be updated. So a lot of them are really out of date. They need to be brought up to date, and we don't have the ability to do that. So it's a major challenge. Some of them are over 20 years old. How do we get them updated? Holding the line on development. With new technology and the money that's out there, there are a lot of people who buy old ranches and who want to build their starter castles on the highest ridge line in the most remote areas, whether it's Big Sur, San Mateo Coast, or Mendocino. And they can do that by being off the grid. They can hook up to satellites, their phones and computers, use solar panels for energy, and they can get water. So they can be remote like that. And they can helicopter in, as we've had some proposals, that they helicopter from work. Well, it now has put areas that we never thought would be under pressure for development, under pressure for development. Holding the line on agricultural lands. A lot of agriculture is just marginally viable, if viable at all. So there's a lot of pressure to convert ag land to subdivisions and development. Holding the line on that is a major challenge. And then we have major developments. Always, the coast is such a precious piece of real estate. Pebble Beach is coming in for a major new golf course, a major subdivision, and we still have some areas that have not been committed to major development and redevelopment. It's a big issue. The whole issue of water quality, protecting the ocean waters against runoff, non-point source pollution, public access. The people who live along the coast, like Malibu, other places, don't want the unwashed masses to come down into what they see as their backyard. So we have this tremendous conflict between residents and just general members of the public who want to come to the beach for recreation. And it's not just keeping guards on the beach to kick people off, it's also having preferential parking programs in coastal communities where you have to live there in order to park, and that's often the only way that you can get there. So public access continues to be a major issue. The whole question of desalination, using the ocean for desalinated water. The siting of liquid natural gas terminals. We have 4 proposals in California, 2 off the Ventura coast, Santa Barbara coast, offshore, 1 at Long Beach, and then 1 humongous one by Chevron Texaco off of Camp Pendleton in northern San Diego County, which would be a huge structure put on the ocean floor just 2.5 miles offshore. Anyway, we have these 4 proposals. We don't need 4, yet we don't have the authority to say, well, this one is preferred environmentally. We got to deal with all 4 of them. The whole question of development on the outer continental shelf continues to be a major issue before us. Power plant modernization, power plants like Moss Landing, Morro Bay, El Segundo, which use old technology of sucking in millions of gallons of ocean water and training larvae, eggs, small fish, destroying all the marine life that gets sucked in, and they want to modernize and continue that way of cooling their plant. It's a major issue that we're dealing with right now. And then ocean issues. There was this Ocean Commission report by the National Ocean Commission, the Pew Commission. The governor has on his desk the California Ocean Protection Act, which I think he's going to sign. So there's a whole focus on what we do to manage ocean resources. And there are a lot of issues. There's ocean ranching. We have a proposal off an offshore platform to locate big pens for fish that would be raised there for the market. Tremendous issues raised there relative to escapement, disease, and the whole question of should we be using the ocean for farm fish that could have tremendous impact on indigenous marine life. Other issues such as aquaculture and then ocean energy. We have a project called the Sea Dog Project off of the Northern California coast where these structures are proposed to be put in the ocean that will use wave energy to run a hydraulic ram that will pump water to a higher elevation onshore, which will then go down through a piping system to run turbines to generate electricity. I told the proponent of that project I thought it was a fool's chase. And you're always damned if you tell them what you think, and you're damned if you don't tell them what you think, because when you tell them later, they accuse you of a late hit. You should have told them before. So I told him to take his project and go away, and he decided he's not going to do that. He's going to go ahead with a pilot project. So we'll have to deal with that. But we're seeing proposals to use the ocean for energy that isn't reliant on fossil fuels. So they're saying, this is the future, you should be allowing this. The whole question of public and private rights, Joe Sachs and those of us on legal staff, or those of us who are lawyers, have been concerned with this issue for many, many years. Joe has been a leading intellectual light on this whole question of how do you balance private rights with public rights, especially in light of the Supreme Court that we have and the decisions made by this Supreme Court in 1987, which after that decision, 9 out of 10 cases where we used to require public access as a dedication of a new project, we don't anymore because of that decision. So the whole conflict between public and private rights continues to be a major issue. Local governments are scared that they're going to get sued for takings of private property. They sign off on projects, and they end up with us, and we'll take the suit. We're probably, right after Caltrans and the Department of Corrections, the Coastal Commission is probably sued more than any other agency in the state. And we haven't lost many of those decisions since the 1987 decision, but that continues to be a major tension. Another issue that we've got now is the whole question of international trade treaties. The question of, do international trade treaties trump the ability of the state to protect its environmental resources? So for example, if we take all of the major private companies proposing desalination facilities are international corporations or subsidiaries of international corporations. And the question is, if we restrict them, are they going to use international trade treaties to try to trump protections in the Coastal Act? So that's an issue we have to deal with. In terms of desalination, the Coastal Commission staff did come out with a report on desalination. It's an update of an earlier one we did. It's on our website. It discusses all of the issues that are raised with respect to locating desalination facilities along the California coast. Clearly, desalination is going to be part of our water future in California. It's the only new source of water that's available out there, other than effective conservation measures and reclamation. But we recognize that desal is going to be part of our future. It's still very expensive. I was told today that Cal-Am down on Monterey Peninsula came in with a cost projection of $1,600 an acre foot. An acre foot is about enough water to provide up to 3 families with water for a year. That's still very expensive. So I'm not sure that that's going to make it as attractive as other sources of water, or, well, they're looking for subsidies too, to have the public subsidize desalination by paying for a lot of the cost of energy, which may be okay for public facilities, but for private, for-profit facilities, I think that's a problem. In any event, desal is a major issue. We have about 20 proposals that are out there. There are probably a dozen facilities that currently exist on the coast. They're small facilities. They're mostly for industrial uses or for emergency backup, not to be a primary source of water for our community. The total production that's out there today is about 2.7 million gallons per day. Proposals on the drawing boards are for over 250 million gallons per day. The largest one in the country is being proposed down in Huntington Beach by a private company, Poseidon Energy. The question with desalination is, where do you build them? Where do you site them? How are they going to function? And who is going to actually run them? So it's where, how, and by whom. Obviously, the larger issues are a safe, reliable source of water. The coastal issues are the siting, the cumulative effect of siting these facilities, co-locating them with existing power plants, which may extend the life of power plants that we think ought to be changed. They ought to get away from using ocean water for cooling, but the desal facilities that are being proposed would rely on that ocean water for their own operations. So that raises a number of issues. The visual impact, the community character, issues relative to siting, the marine biology impacts, the discharge of brines and chemicals from these facilities is a major issue. A major issue is entrainment. If you use ocean waters directly to suck in and then convert it to desalination or desalinated water, you entrain, you suck in a lot of marine life, which ends up being killed. So that can be addressed too by having beach wells or having wells that don't take water directly out of the ocean. But there are issues that have to be addressed. And then the whole question of the growth-inducing impact of these facilities. Are they going to open up areas to development that wouldn't otherwise be open because they don't have water right now? And then the whole issue of public versus private. The staff feels very strongly, and the Commission has been supportive of the notion that we should only have public desalination facilities, not private for-profit facilities, putting a straw in the ocean, a public trust resource for private profit. That has been very controversial. We obviously have run into a lot of opposition both in Sacramento and in Washington over this, but I think there's a lot of public support for this notion. I mean, once we start opening the ocean for private for-profit desal facilities, you can just imagine the cumulative effect and the proliferation of these facilities. Plus, there are just major differences between a public entity and a private entity, not to mention the transparency of the process, security issues, rates, et cetera. And then we have the international trade treaty agreements as an issue. We had a proposal from this Canadian outfit to take water from the Wallala River and the Albion River, I think it was, put them into these huge bags, I mean, football fields long, and haul them by tug to Southern California and provide the water for them. Well, we thought that was a really screwy idea. And about the time that we were ready to write a letter to that effect, and did, the Coastal Commission did go on record opposing it, the proponent raised international trade treaties and said, you can't do this. If you do this, you're undermining our ability to make a profit, and that's against NAFTA. And we can take you to the World Trade Organization. Because we opposed it, and I mean, they dropped the project, so they never challenged it. I wish they had. That would have been a great poster child for how insidious international trade treaties are in terms of local community control over their own destiny. Because that's what's happening all over the world, that these trade treaties are really trumping local communities, especially in water, whether it's water supply and provisions. You've probably all read about some of these stories of international water companies coming into local communities and taking over the water and basically sticking it to the local communities. So that's an issue that desal raises too. We do intend to review these on a case-by-case basis. Most will require approval from the Coastal Commission. If you have any questions, I'll get to those. Let me just go over quickly the biggest weaknesses I see in California's coastal protection program. Number one is funding. We tried, but we couldn't get a stable, reliable, predictable source of funding for the Commission. We did under Proposition 20, so that for 5 years, the Commission didn't have to worry about its budget because the funding was secure. We couldn't get that in '76. It would have required a 2/3 vote of the legislature. We just, as I said, barely got 2 votes above a majority. So we never got that, and year after year, that is a major, major battle for us to try to get the funding to do an adequate job to carry out that law. I think that's going to have to be addressed in the future, but it's the single most significant weakness. I mentioned the coastal zone boundary, which isn't adequate. It doesn't go in far enough. It doesn't include watersheds. These outdated local coastal plans, the fact that we didn't have the authority, which was amended out at the last minute. We had it proposed to be able to update these local coastal plans. That was amended out because of the opposition of local government, and now we're stuck with these outdated plans. We're trying to work with local government to get them updated, but it's a major weakness. The fact that we have no jurisdiction over affordable housing. We did have it in the '76 Act. We did require affordable housing. We knew that the coast was going to become inaccessible to people of moderate means, much less people of low income. We made it work. We actually have an affordable housing program that we're still running in Orange County, but the legislature amended that out of the Act in 1979 at the behest of the developers and local governments. And I've always been really bitter about that because we were making it work. Inclusionary zoning, we just said 25% of a new subdivision would have to be affordable housing in perpetuity, and then have resale controls. that was viewed by Orange County and others as being a socialist, communist plot. We couldn't defeat the legislation. It was taken out of our jurisdiction. It was handed to local governments, and they have done virtually nothing to protect affordable housing. And look what's happening to housing along the coast. People who come there to work can't afford to live there. That, to me, is another major weakness. The power of special interests and the politics of coastal protection is another weakness. One of my pet peeves over the years has been we should have banned, we tried, but couldn't get it through, ex-parte communications. That is, communications with commissioners outside the public hearing process by developers or anybody, really. There's a tremendous influence by special lobbyists who represent developers, who come to the commission meetings, they meet with commissioners, and they really work the system to get projects through and who have that kind of access and that influence. The environmental community, local civic groups simply can't keep up with the money that special interests bring to bear. So that was another, and we tried this year to get a bill that would just ban these private conversations for matters that are in court, litigation, or that we have an enforcement proceeding, and we couldn't get it through the legislature. So that's another major weakness. Another weakness is telling our story. We can't tell the story of the Coastal Commission because our major accomplishments are things you don't see. It's the subdivisions that didn't occur. It's the wetland that wasn't filled. It's the public access that wasn't lost. So, you know, people don't know, like projects along the coast that have signs that say, this stairway was brought to you by the State Coastal Conservancy. We can't put up signs saying, this view was protected by the California Coastal Commission. We'd wipe it out with a sign in the first place, but you know, you can't tell that story. It's just one of the major, it's a reality that we have to deal with. So a lot of people don't know what it took to protect the coast as it is today. The final major weakness is sustaining public participation. It's become very complex to participate in our program. The laws, the courts have played a major role in deciding how policies ought to be implemented, and it's very difficult for the public to participate on an ongoing basis. It takes sophistication, homework, knowledge, and it's really hard, and it's very expensive to participate. So, and that was another thing we tried to do, is have a public advisor like the Energy Commission so we could actually help the public participate, and that we couldn't get into the law either. In terms of strengths, clearly this is a public law. I know I got to wrap up here. This is a public law. The people support it. Every time it's been challenged, the public has come forward and protected it vigorously. It's the strongest law, I thought, in the world until a friend of mine today said, no, you forget that in China, if you violate their zoning ordinance, the penalty is death. So China has a stronger law than we do. But if you've been there, you see it's not very effective. And then the challenges in terms of what lies ahead, clearly the coast is never saved. Like any precious geography, it's always being saved. That's why our job is never done. It's always being done. So it's never over. Working with a new administration, the governor has made 3 appointments to the Coastal Commission. He's appointed a person who runs an environmental law program at Stanford, Meg Caldwell, who's outstanding. Her background in environmental and land use is incredibly strong. Another public member who is a very decent guy but has no background in this area, and the jury's out there. And then a locally elected official who used to be on the Coastal Commission, who's supportive of the Coastal Act. So, and he's appointed some good people in terms of resource secretary, environmental protection agency, but then there are some people directly in the governor's office who are vehemently opposed to the Coastal Commission and the Coastal Act. And frankly, I have no idea how the tension between that kind of conservatism and keep government out of land use control is going to shake out with those appointees who really believe in conservation and what the governor said in his election campaign, which is, I'm going to protect the integrity of the Coastal Commission and the Coastal Act and protect the ocean. So that's the challenge that we have. the politics of coastal management have really changed with term limits. I can't even begin to tell you what a difference that the institution of term limits in California has done to environmental policy. We just lost the dean, the champion of environmental stewardship in the state Senate and the legislature in Byron Chair because of term limits. There's nobody who comes along because you can't. You're limited to 6 years in the Assembly, 8 years in the Senate. You can't build up the kind of expertise and be a champion of environmental protection under the terms and conditions and the dynamics of term limits in Sacramento. It's a major, major loss in terms of protecting community and environmental values. Avoiding client capture, I think we've done a good job avoiding control of the commission by developers, certainly in terms of the staff. There is that concern about the influence they have on commissioners, but that continues to be a challenge. How do we avoid being captured by those very interests that we are charged with regulating, as well as not being captured by the public sector? So, and then integrating, the final thing is integrating the dry side with the wet side. How do we make sure that we're integrating what we're doing in the watersheds that affects marine water quality with the emerging programs to manage the ocean resources on the wet side? So I've run over by about 10 minutes, 14 minutes. Let me turn it over to you for questions, and I'll be happy, and I'll stick around afterward too to answer any questions. So.
Actually, we have about, I'd say, 15 minutes at least for questions. So Peter can take questions from the audience, and I don't think we're going to need the mic, but we might. So
I'll try to repeat the questions. Yes, sir, in the back.
The state of Hawaii has complete public access to all beaches, the hotels in front of Waikiki, to the most remote public and private land. Why can't we have that in California?
I'm not sure I agree with you in terms of the public access, but be that as it may, you may have had different experiences than I had when I was in Hawaii. There is a different cultural background. California, there are lots of beaches that have been historically private, and they continue to be private. We have worked hard to try to open up those beaches, but because of the decision of the Nolan case in 1987, we're having a real hard time legally opening up beaches that we can't show a direct nexus, an impact of the development on public access, existing public access to impose the condition. You look at places like the Hearst Ranch in San Luis Obispo County, there's a major issue going on right now in terms of a conservation easement that's being proposed with a public access program that I think is inadequate. That's why we're opposing it. I'm the only public official who's gone out in opposition to that plan, in large part because it doesn't do enough for public access. All those beaches have been private. Hearst Ranch has opened them up to people and said, we're letting you use this by our permission, but we can block it off at any time. Hollister Ranch at Point Conception in Santa Barbara County, 8 miles of coastline that's absolutely off limits to the public. Even though the public trust lands, that is the lands that are subject to wave uprush, mean high tide line, are public lands. So if you can get there by boat, you can legally stay there, but you can't get at it from the land side. And that's because of the history of law in California and our cultural background, which is quite different from Hawaii. So and as I say, this is a major issue for us in terms of how do we get increased public access, especially as population continues to increase and we lose some of these recreational areas in the upland areas. Yes.
I have 2 questions. One is, how are the rights of Native Americans handled in this? I know that Native Americans' water rights are handled by the federal government. Is there any representation for them in the commission? The second question is, how far can the Coastal Commission exercise its jurisdiction It's about 12 miles or so for international waters. Can you go beyond the international waters? What if somebody from some other country does something? Can you do anything about it?
Okay, well, let me start with the first one. In terms of Native American interests, we don't have a policy in the Coastal Act that protects cultural resources. We tried to get a bill through this last year, got stuck on the Senate floor. We couldn't get it through. We do have a policy that protects archaeological resources, which are different. But we have really stretched the envelope to protect Native American cultural resources in the coastal zone with development. And I think we've done a better job than just about anybody else by insisting that developers have Native Americans on site, stop development. You can't just take the remains of Native Americans, put them in a box, put them in a museum or somewhere else. They actually have to, we think, do what the Native Americans who are ancestors, or yes, what they, not ancestors, they're their descendants, what they think ought to happen. We just did that in Orange County, and what was the resolution was to set aside an area for the remains to be reburied and to have a museum that basically tells the story of Native Americans. So it is an issue that we are very concerned about. We have a very good working relationship with the tribes. We also deal with casinos. And because of our federal consistency authority, we've asserted that in a number of rancherias on the North Coast, saying, you have to get approval from us. You can't just build this casino right on the water's edge or that has these impacts. So we've been able to influence redesign of several casinos along the coast. As far as how far can we can go as far as we need to go. As I mentioned, the Navy, that was over 340 miles off the coast. But that was a federal agency proposing to take an action. If another country proposes to take an action, we can't do anything about that. But federal agencies, we can go as far inland as we need to go. For example, the surprise, surprise, this administration is proposing to open up portions of Los Padres National Forest to oil drilling. That's the Big Sur coast. And that's inland of the coastal zone boundary. And we have said, you have to get approval from us for that. And so we'll go as far as we have to go, as long as we can show that there's an impact on coastal resources within that zone by the proposed federal action, either by the federal agency itself, or a grant that they're going to give, or a permit that they have to give. But as far as other countries, we don't have jurisdiction over that. Yes, sir.
How secure do you feel the federal consistency provision is?
There was a period where I thought that was going to be weakened this last year by this Congress and this administration. They certainly tried, the energy companies especially, but they had to back off. And the Department of Defense. After 9/11, they tried to, and they did, get a lot of exemptions from environmental laws, but the Coastal Zone Management Act was not included in that. I think there's just a lot of support for federal consistency, and I think it'd be really tough to amend the federal act to substantially weaken it. Unfortunately, the administration of that law by the National Oceanic and Atmospheric Administration itself passed regulations to substantially weaken the application of that law. And we opposed that, objected to it, but we couldn't change that. But in terms of actually changing the statute to take it out of the ability of coastal states, I don't think that's going to happen because there's too much support for it. So, yes, sir.
Yeah, and the new sort of proposal for this performance review, almost every agency that has gotten at least some experience with the public trust is being fractionated in its authority. And just seeing that in the treatment of water in California, with the, this creation of an infrastructure department instead of water resources. And do you see your ability to keep the public trust intact through this process?
They did not propose reorganizing the Coastal Commission or moving us somewhere else. They did propose taking away our jurisdiction over LNG siting, liquid natural gas terminals, and petroleum facilities. But I think that's not going to go anywhere because of the public opposition to doing that. Other than that, they didn't propose any changes in our jurisdiction, which I'm glad to say. Yes, ma'am.
I guess along the same lines, BCDC also had proposals in the California Performance Review related to some of its regulation and jurisdiction. And that brought up this idea of duplication with other agencies. And I'm just curious what kind of challenges the Coastal Commission faces dealing with other agencies with jurisdiction in the coastal zone, and how you address it.
Well, I don't personally hide the fact that duplication is a good thing. There are those people who say, well, gee, that's not efficient government. Well, it is efficient if you want to protect the environment. Because, as we know, there are many agencies who basically are fronts for development, extractive industries and for developers. And that's the reason we passed the Coastal Initiative, was because the agencies that had responsibility for protecting the environment weren't doing it. So from our perspective, saying that you should just consolidate all of this, that's just a euphemism for let's get rid of the barriers that are in the way of development and growth and basically destruction of the environment. So, and fortunately, they didn't propose taking that away from the Coastal Commission. I know BCDC was treated a little differently, and I hope they succeed in beating back those efforts to cut into their jurisdiction. But that's always been an argument right from the beginning. You're going to be interfering with the responsibilities of Caltrans, which is a developer agency, or the Department of Fish and Game, or the Department of Parks and Recreation, or the Water Resources Control Board, or the regional boards. The fact of the matter is we do a different job, and we have different policies to carry out which are protective of the environment in a way that no other agency has. So we'll just continue, and we're not going to hide that fact. In fact, it's just like the label liberal. I'm not afraid of that. So, yes, sir.
You're sort of in the category of living legends of environmental administrators in California. I don't think
my age shows.
This is not an original observation, but you've been doing this a long time, and it must be frustrating, the efforts of greed and stupidity and all that. How do you stay motivated doing this?
Well, as I told the Sierra Club, I was honored with the Distinguished Service Award Saturday night by the Sierra Club, and it really was a profound honor to me. And as I look out there, I mean, the work that we do at the Coastal Commission, we're not competitive. In fact, one of the challenges that I didn't mention is just retaining good staff, because we're not competitive with what local government pays or other special districts. So for us, it's a labor of love. It's a labor of love that's in process, and it never is done. It's always being done. And when I look at the forces of, the power of developers, or the myopic nature of our political leadership, where they can't see past the next election, or just the mindless consumerism that's destroying the planet, it's easy to have resignation and despair kind of gnaw at your roots of determination and resolve. And whenever that happens to me, I just think of the young, all manner of life, and I turn to nature. And I get renewed, get my batteries recharged by going for a walk on the beach or in the Sierra or in the desert. And I think all of us who work at the Coastal Commission, first of all, you have to be an idealist to work there. Secondly, you have to have a really thick skin. And then you have to be resilient. You have to understand it's a labor of love, and you have to be able to understand this is a job that's never done. And you have to not be afraid of conflict. And that's what's happening in so many arenas these days, that people who are in elected office or environmental groups, mainstream environmental groups, who are afraid of conflict. They're afraid they're going to be left off. They won't be at the table, or they won't have access in the halls of power. Well, there's a difference between having access to power and having real power. So it seems to me that you have to stand up and speak truth to power and have the courage to do that. Instead of running away from conflict, being afraid of it, avoiding it, and saying, gee, we need a consensus decision here. The whole notion of consensus decision making. It's nice to get people together and try to work together, but if you're saying you can't make a decision unless everybody agrees, that's the tyranny of the minority, and it means the destruction of the environment. So all of those things combined, plus the inspiration that we get working for the Coastal Commission from the public out there. I mean, to me, when I'm asked what's your #1 accomplishment at the Coastal Commission, I mean, there's no question in my mind, it's the terrific staff we put together that do the public's business day in and day out and who believe in it. And secondly, it's the inspiration we get from the public. The public that participates, that works with us, that supports a strong environmental stewardship program like we have at the Coastal Commission. So, and it's not just a job. I mean, if it were a job, I'm the only non-civil service appointee or employee of the Coastal Commission. I was appointed, there are 12 commissioners. I was appointed on a 7-to-5 vote. So I had to count to 7 to get my job. And since then, I've only had to count to 6 to keep it. And there have been probably a dozen attempts to get rid of me. And every time that's happened, what they misunderstand and don't grok is the fact that this is not a job for me. This is a labor of love. I mean, I'm still amazed that I wake up in the morning and I get paid for what I do. So, you know, those are the things that keep me going because I believe in it. Plus, all of us who work at the Coastal Commission, we believe in public service. And that's a key part. I went to law school. I had a lot of colleagues who were talking about how much money they were going to make when they get out. Well, I feel, since I'm an immigrant to this country and what I got, what was given to me, I want to give back. And public service is one way to do it. And I think everybody at the Coastal Commission they stay there because they believe in public service and their ideals.
Another way of charging one's batteries is listening to you. So,
thank you. Yeah. Can I just? Yes, ma'am.
2 things. A, where can we see the boundaries of the Coastal Commission? And B, you think this guy who's a local official who wants to make a city of this large hunk of Northern California is going to get away with that?
Well, that's, I'm not familiar with that.
It's been featured in the media recently.
It's what?
It was featured in the media recently.
I don't know. We don't have any jurisdiction over new local cities that want to incorporate along the coast. When they propose development and plans, that's when we get involved. In terms of the coastal zone boundary, those are maps that we have on file at the Commission offices. So you can call our office and come in and look at those and look at the area that you're interested in along the coast. Okay.
One last question.
Okay.
I cannot resist making a comment after what you've said just now about this job being a labor of love. And there are a lot of things going on in our contemporary society about war and so forth. There is so much of hatred about the United States and things of that sort. At the same time, this country has also a different kind of leadership, which historically in the last 60, 70 years started with the wilderness movement and the environmental movement and the NGOs. Essentially what John Muir started has grown into a fifth or the fourth or fifth arm of the government, which is a sort of, in an unwritten way, stands up and speaks against the government. And that has various manifestations, this leadership, and nicely enough, this is spreading to places like India, where we have very serious problems about the environment. There are lots of NGOs are sprouting up, and people are speaking, and this is precisely the thing that people get interested and begin to participate. And I think loud and clear it came from your own personal the way you have grown and you have evolved in this job, I think that's what I couldn't resist mentioning, that this is part of the leadership that comes out of this country, which is not the same leadership which sometimes we feel a little bit uneasy about. But this leadership exists, and that's why maybe this young woman sat on top of a tree for 2 years.
No, you're absolutely right, and we do have a lot to be proud of in terms of the example that we set. But let me just recommend a book to you that I just finished that I thought was really profound and very compelling, and that's Jeremy Rifkin's latest book, The European Dream. He compares the European Union's dream for a future in a global economy and a small global community with the American dream. And when you look at the values that they're promoting, such as human rights, cultural diversity, not assimilation, the rights of nature, animal rights, the quality of life as opposed to consuming, acquiring material possessions, just how you live your life. It's a very fascinating contrast. And when you look at that, one of the things that comes through is Europe 25 years ago, or after the war, I mean, they were so far behind the United States in terms of environmental awareness, environmental leadership. They have since passed us up. When you look at what they're doing now in terms of global warming, international treaties dealing with environmental issues, they have left the United States behind. We can't sign Kyoto, we won't agree to some of those international. They have seen what the impact is on their communities. The United States is going the other way. So yes, we've provided leadership, but I suggest that it's time that we take some lessons from other communities in the world who've passed us up. So with that, thank you for your attentiveness. And,